Hello, this is Michael Brown with Avalon Risk Management, your premier provider of insurance and surety solutions for the transportation industry. In our last episode, Kathy Schricker provided an overview of the process of registering with the FMCSA as either a transportation broker or domestic surface freight forwarder. She also provided information on the FMCSA's Uniform Carrier Registration Final Rule. There are more than 700,000 motor carriers registered with the FMCSA. The agency believes that at least 500,000 are actively hauling freight. Today I will discuss some important changes that MAP-21 imposes on motor carriers. While many parts of this new law impact motor carriers, perhaps one of the most significant relates to carriers who hand loads off to other carriers. For years, many motor carriers have accepted loads that they did not intend to move on their own vehicles. MAP-21 clarifies that this is in fact brokerage and requires carriers that engage in this practice to have separate brokerage authority and evidence of financial responsibility. The law also requires that they disclose in writing in advance as to which authority they will be accepting the load under. MAP-21 does allow motor carriers to engage in interlining without becoming separately registered with the FMCSA as a broker, but the practice is narrowly defined. MAP-21 stipulates that in order for a transaction to be considered interlining, the load must have moved on the motor carrier's own equipment for at least a portion of the transit. If the transportation is performed entirely by another carrier, then this will be considered brokerage. MAP-21 makes motor carriers that engage in brokerage without being properly registered and bonded subject to civil penalties payable to the U.S. government of $10,000 per violation. The FMCSA is developing its enforcement strategy, but in the meantime has set up a tip line so that the public can report carriers who broker loads without being properly registered and bonded. In addition to being liable to the government to pay penalties, MAP-21 makes those operating without proper brokerage authority and evidence of financial responsibility liable to the injured party for all valid claims incurred without regard to amount. The FMCSA explicitly warned motor carriers who illegally broker loads of this fact in their September 5th Federal Register notice. In addition to imposing the aforementioned fines and liabilities on motor carriers who broker freight without the proper authority, MAP-21 also makes the officers, directors, and principals of these companies liable as individuals to pay these amounts. These are significant liabilities, and those motor carriers who engage in brokerage need to obtain separate authority immediately. When obtaining brokerage authority, however, motor carriers should carefully consider their organizational structure. Many auto liability insurers will not provide coverage to carriers that operate as both a motor carrier and transportation broker within the same legal entity. This is because when accidents occur, plaintiff's counsel can allege that the company was acting as a carrier rather than a broker. To a third-party observer, a broker hiring a carrier and a carrier hiring an owner-operator to work under the carrier's authority appear to be very similar. Truck insurers are generally not comfortable assuming bodily injury liability for claims on a primary basis for loads that are brokered. For these reasons, motor carriers may want to consider creating a separate legal entity for their brokerage operations. It is important to note, however, that if a carrier accepts a load and then hands it off to their sister company that is a properly registered broker, this is still in violation of the law. The company that accepts the load must themselves have broker authority. To be in compliance in these situations, the carrier would need to refer the shipment to their broker sister company and allow them to accept the load. There are a variety of things to consider when creating an organizational structure, such as tax liability and corporate veil issues. Motor carriers should consult with a qualified attorney and perhaps a tax expert when doing so. In the FMCSA's notice published in the Federal Register on September 5th, they strongly encourage all motor carriers not to accept loads from unregistered brokers or freight forwarders. I hope that you found this information helpful. In our next episode, we will discuss the risks associated with selecting motor carriers. Thanks for watching.